you, Judge. I couldn't access it at the time because I don't have access to our closed files. Our dismissal order.
So, okay.
There was never a suspension.
The defense attorney is challenging the judge's earlier order not to drive, claiming it was based on incorrect information about an ALR suspension. This is a high-stakes moment. If the suspension was invalid, the defendant's entire bond condition could be called into question. The judge is about to face a tough decision. Stick to the original order or admit a mistake.
On his license at all. He's been good to drive.
But he was also drinking. The concern was that he was drinking.
But Judge, you told him before you left that that you were doing this because there was already a suspension on his license that he couldn't drive. I never got the impression that you were taking that action because he was drinking.
He was drinking allegedly, and
yes.
The license was suspended.
Yes.
Can you run his license, please, state?
Your Honor, this should be eligible to.
Did it just become eligible, or when was it eligible? You know what? Let's do this. I have a line of people. I've got arraignments. Let me put this off a little bit because this is going to take a lot more time.
I have to go to the doctor's office. I sent you an email on Friday when you said this. I'm supposed to be at the doctor. I took today off, but I never got a response that when I asked to move this to tomorrow. So I've got to get it done. I've got to be at the doctor.
So we can do it tomorrow. You want to do tomorrow?
Let
me look at
I'm already here.
Your Honor, it looks like it was lifted on 4/2/2025.
So what day was it lifted?
4/2/2025, from what I can see on the license. It's the ICC.
And what are the days that he's alleged to be driving?
The second, Judge, let me double check.
And does he have an interlock as well?
Yes, Judge, he has an interlock. He was alleged to be driving on the second and the third.
Furthermore, Judge.
The license was lifted on the 25th of April, 2025, but the defendant was allegedly driving on the 2nd and 3rd. The defense is arguing that the court's no driving order was based on a false premise. This is a classic case of bureaucratic confusion clashing with legal authority. The judge's patience is being tested.
The bond conditions that you signed on the 28th, nothing on those bond conditions says he can't drive. And my client tells me that when he went to pretrial services, he was told repeatedly, because he asked repeatedly, if he could drive. And so I think pretrial has the apparent authority to tell him what the bond conditions are, especially for somebody, a lay person who, when he goes there, he doesn't.
There is a no driving affidavit on file as of March 28th, where I ordered him not to drive. Just because you think you can drive doesn't give you the right to just go start driving in violation of a court order. You come here, you ask for permission, and then we give you permission. You don't just go do something and ask for forgiveness after the fact.
It's told by pretrial services.
I don't give a damn who Jesus tells him.
Judge, you don't.
Doesn't matter. A court order is a damn court order. Just because pretrial services tells you something doesn't. Really? Is that what it's now come to?
This was all premised on wrong information that he couldn't drive. He can drive. There's nothing wrong with this license. There was no ALR suspension ever. The state told you that. That's why you.
It was a suspension.
It was not an ALR suspension. There was no ALR suspension. I got the case dismissed. It's not possible. I mean, would you like to see the email or the dismissal ordinance from jurisdiction? Because it's right here.
Dude, I'm just looking at the records.
That's fine. I'm showing you.
The suspension, it was begin date 1/3/2025, lift date 4/2/2025.
It's not possible because it was dismissed with prejudice.
Yeah, 12/6/2024, end date 6/3/2025, and the lift date comes in at.
And then if that,
I'm not saying you're wrong. What I'm saying is based on what I can see is what I can see.
if there's a dismissal.
And incorrect information about his driving rights. But the judge isn't having it. Court orders are absolute, regardless of who miscommunicated what. This is a critical lesson in legal hierarchy. Only the court's word is final. Void
Order, then that suspension is contrary to law, and it's void.
I'm going on what DPS says. I don't have access to what you have. I don't know. All I know is Please, you don't need to put your computer. All I'm saying is that regardless, Mr. Johnson,